Good evening and welcome to the Lakewood Board of Adjustment regular meeting on July 22nd, 2020. It is 7 p.m. and I call this meeting to order. Will the clerk please call the roll?
Board Member Bartlett?
Here.
Board Member Cohn?
Here.
Board Member Heel?
Here.
Board Member Kentner?
Here.
Board Member Miller?
Here.
Board Member Peters?
Here.
Board Member Stone?
Here.
We have a quorum.
Very good. Thank you, Mr. Schultz. Before we ask you to read agenda item 3, I'd like to ask if Bill Tuthill, he wanted to make a couple of comments. I'd like to see if you'd like to do that now.
Sure, I'm happy to do that. Agenda item 3 relates to a follow-up discussion for the board on matters that were considered in January of this year and matters which were considered by the board at your last meeting. If I could just provide a little bit of an update as to where things currently stand, I'd like to be able to do that. As you know, there was a complaint filed against the board in February. There was an answer I filed on behalf of the board. There has been a motion for partial summary judgment on one of the claims. There's a motion to dismiss the third claim for relief, which does not involve the board. Those matters have all been fully briefed, and I expect no action to be taken at any time soon on those. For several reasons. The first is that the parties have notified the court that there is a mediation set for the 14th of August. There has been a pre-mediation conference that occurred a week or so ago with the mediator, with the attorneys for the parties, including Director Parker, myself, and Mr. Heald listened in on that. There is a follow-up pre-mediation discussion, which I'm happy to tell you more as to why the mediator is doing that, scheduled for tomorrow morning at 10:30. And the mediation is scheduled for August 14th. In my experience, no district court judge is going to take any action on the pending motions when he knows that a settlement conference is upcoming, because he would just love for this case to go away in some manner that does not require him to make an effort on it. And today, again, the Jefferson County Chief Judge issued a directive that indicated that trials are really going to be pushed way, way back because of courtroom space limitations, the need to deal with criminal matters first on their docket, and that civil cases were going to take a very far back seat in getting resolved. So although there are issues pending before the court, I don't expect anything to happen in the immediate future. So other than the mediation, which is scheduled for next month. So that's the update, Chairman.
Thank you.
Oh, I'd like to mention one other thing if I could. There are actually 2 lawsuits pending, one of which does not involve the Board of Adjustment, but which does involve the City Council and the developer, and that relates to allocations of residential building permits under Lakewood's new code provisions that were adopted by the citizens last fall. And so both of those matters are currently pending in the district court. I have nothing to do with the allocation case, but I can tell you that as they discuss the prospect of whether or not there can be any sort of a settlement, the other parties are interested in whether that's something they can work out as well.
Okay, very good. Thank you, Bill. And I just want to point out before we move on that we will take up the discussion further on mediation under general business. we have some things to discuss there, but that's where we will do that. So with that, Mr. Schultz, will you read agenda item 3, please?
Item 3, discussion of the board's options with regards to the litigation against the board regarding the White Fence Farm redevelopment.
Very good, thank you. At this point, I will entertain a raising of hands for people that want to discuss at this point. I'm not seeing any hands. Very well then, at this point, with no discussion of the board's options.
I think Teresa had her
hand. Rhonda, Peters.
Well, I think Teresa raised her hand and it wasn't clear. I didn't know if you wanted for us to discuss or
Well,
what are you asking for exactly?
let me clarify. As we left this the last time, we set this agenda to further discuss the board's options. So what I'm trying to do here is open for board discussion, and I would like for us to use the raise your hand feature on the screen so I can see that in the panel on the right as opposed to looking for raised hands. But what to answer your question, I think at this point we need to continue our discussion on the board's options. We opened that subject last time and set this meeting to continue a discussion of our options. So I think anybody that has input, now is a good time to bring it up. Is that clear? We don't have to. We can go, somebody could make a request to go into executive session and we could go at that point. I see a Johan wave over there. Mr. Cohn?
I don't have a motion, but I did want to ask Mr. Tudhill a question. Is the proposed case management order that was drafted on 4/15/20, or at least has that date, is that in effect now, or has there been any action taken?
If you didn't get a copy of these days they sign them electronically, but the answer is yes, that case management order was entered by the court in April and controls. And one of the things it does that's a little different than a normal case management order is the court and the parties recognized that there are motions relating to the first and third claims for relief in the case. And depending on how those motions are resolved, it affects what the case looks like. I mean, if the court were to decide, for example, that there hasn't been a decision by the board on some of the issues that are appealable, then there's nothing for the court to do on those claims. They're not going to order discovery on the second claim for relief because that's purely a record review. And so the parties all agreed during the case management conference, which took place with the judge over the phone, that it was important to understand where those claims stood before you moved forward. So the case management order kind of is it's not as detailed as a case management order might be, but it has been entered.
Okay. Thank you.
Hey, I see Dale Miller has a hand up. Dale?
Thank you. You were asking just if there was comment or discussion in general, and I do have a comment, but I wanted to ask Bill also, how long does this sort of mediation tend to go on? Since we know there's developers who usually have some sort of schedule they're trying to keep, other people who want to get things done. What would your experience?
I would expect that, and I'm not familiar with this particular mediator. I've never used him before. And this case has a number of moving parts, but his objective for tomorrow's meeting is, and Mr. Heald, you can confirm this, he would like to find out to discuss two things. The legal realities at the moment is how he described it, that temper people's thinking. And the second was to whether either of the main parties, and I described that as the developer and the homeowners, because the board is a party and Mr. Parker and the city are parties, but I've made it clear that the board can't take any action at a settlement meeting. Okay, it's simply not possible. Even if you gave me direction tonight, you can only act at a regular meeting. And so the mediator has asked if the parties who are the main players can create what he described as a template of proposals that might help move toward resolution without driving someone from the table. And so tomorrow is the precursor to whether people can propose templates, and August 14th will kind of be the more telling outcome. It's a development project. At some point in time, there need to be city approvals, whether they come from the Planning Commission, the Board of Adjustment, the City Council. It's not going to happen in a void. But I think my personal impression is that, I mean, to my surprise, this was not an all or nothing proposition when they talked about setting up a settlement discussion. I think the homeowners understand that there's a vacant restaurant that is currently, running down in a parking lot that's deteriorating, and graffiti and the sort of stuff that happens with an abandoned property, and that there will be some form of redevelopment. And the redeveloper has sunk a bunch of money into the process already and is not yet prepared to walk away. And so each of them said there might be outcomes that will satisfy all of us. And let's not just decide that it's a total win or lose proposition. And I was a little surprised to hear that the first time, because when we drafted, this goes back to Mr. Cohn's question, when we drafted the case management order, you're required to put in a portion that talks about whether you think there's any prospect for settling the case. And my personal reaction was, I doubt it. And yet the developer and the homeowners said, no, don't give up on that. And I'm like, fine, I don't have a horse in the race, so that's great by me. So to answer your question, I think we'll have a much better feel, obviously, on the 14th of August. But anything that happens, this is not the sort of thing that they can just sign an agreement and be done with it. There's going to have to go back to the city at some place, whether it's through the planning director, the planning commission, the Board of Adjustment, or the city council. There's going to be a process. The question is whether the main parties can come to something that each of them could probably endorse.
Thank you. So
I would just add that that's very complete. Thank you, Bill. And just want to underscore that tomorrow's meeting is another pre-meeting. It's not actually a mediation. It's a continuation really of the pre-meeting regarding logistics and crafting the actual plan to begin mediation. Is that right, Bill?
Yeah, I mean, he described it, and I have to say, I've never seen quite this process before, but he described it as can you propose a template, knowing that there are uncertainties relating to potential outcome, both in court and through a public hearing process at some point in the future. But nobody expects this land to remain vacant forever or abandoned forever.
Yeah, I agree with that. That's kind of what comments that I've heard about it too. I want my comment in general was about this process that I'm glad that they are in mediation. Everyone's more likely to be happy with the outcome if they agree to it themselves, instead of, as you were saying, Bill, rather than going to court or from us or whatever. So I'm happy for that. I wish them the best of luck, because I think if they have a motivated developer and involved homeowners associations, they're going to do some good negotiating, and everyone will probably be happy at the end. I like that. As far as our role, I feel like we should sort of just keep an eye. I mean, obviously we're named in the suit if there's a suit, but right now there isn't one because, as you say, they're going to mediation. And I believe we should just be sitting back. I've written some email. Probably everyone has seen that I have a I have a feeling, a sense that we should just, that Mr. Tuthill should be going as our liaison to these meetings and reporting back to us. Any of us that would be there could, we wouldn't want to send any signals or wrong signals or right signals or whatever else. We'd just let them do their thing. That's my feeling about that.
And if I can jump in here, I'm just going to reiterate that I have told the other parties and the mediator that I view, at the moment, I view my role as very keenly interested observer to see what the other parties talk about. It is not my job or role to help them find common ground or to take a position on behalf of the board. And I have made it clear that anything that, this may never come back in front of the Board of Adjustment, depending on how things proceed. But that there is no preconceived outcome that the board can commit to, nor will it. And so I've been adamant that I would like to be there, so you've got eyes and ears. But beyond that, I'm not trying to find an outcome that works for them. I want to see what they talk about.
Great. Thank you.
Thank you, Bill. I see two hands up. Johan has had a physical hand up for a while, and then, oh, Dale, are you finished? I'm sorry.
Just one comment. I was just going to say thank you.
Oh, go right. I'm sorry. I didn't mean to cut you off.
Like 30 seconds. I was going to say thank you, Bill. And I also love these meetings because we can watch your cat walk around behind you while you're talking.
Yeah, sorry about that. It's only bad when she walked across the keyboard.
Yeah. That wouldn't be good in a Zoom meeting. Okay, so going ahead here, Johan had a hand up first, and then I believe a physical hand, and then Teresa raised an electronic hand. So we'll start with Johan.
You know, I'm about where Commissioner Miller is in thinking, and I too believe we should have as passive a role as possible. But I also notice that this is court-ordered mediation, and we're a named defendant. Can we maintain that kind of role throughout? And this question is for Mr. Tuthill.
I think you can remain, well, I think you're going to end up remaining a party under almost any circumstances. And I know that, you know, we've kicked around some other ideas, but there's a rule of civil procedure, which is Rule 19, that provides that people who are indispensable parties can be required to participate in litigation, whether they like it or not. So sometimes people name like the Board of Assessment Appeals or the Board of Equalization because they want the dispute, the resolution of the dispute to be binding on whoever is in there. And so, you know, even if we had never showed up in court, I think someone would, you know, make you an involuntary party. I don't know that you have to take a position. And I will remind the board that with regard to some of the claims in the complaint, in the answer, I took no position because the board did not have a majority position. And that's admittedly very unusual. I can't recall a case in which I've done that in the past, but I will continue to maintain that unless the board directs me differently, with regard to some of the claims for relief, the board takes no position. And the other parties can duke it out and you'll be bound by whatever result the court comes up with. To the extent that they direct you to do anything, they may not, or he may not. But that's the long answer to your question. Can we sort of maintain a neutral position and just kind of be an observer? I think to a large extent, that's what I'm trying to accomplish. Now, keep in mind that the city, on behalf of Director Parker, has taken a position of advocacy with regard to some of these issues. But I don't represent the city, I represent the Board of Adjustment.
Okay, very well. Then, does that conclude your question, Johan?
Yes. Yeah.
Okay, thank you. Teresa, I believe you have a hand up.
So just a couple of questions. I just want to clarify, Mr. Tudhill, the legal realities that the mediator is referring to are the logistical realities that you talked about in court. Is there anything else besides that? The scheduling, the prioritization stuff. What does he mean?
I'm not sure what he's thinking of, but he wants the parties to come in and basically say, okay. I mean, sometimes when you talk about the legal realities, it's a question of how long is it going to be before we get a decision out of the court? What is it going to cost us to get there? What is the likelihood that someone appeals from that and delays the process further? As well as the likelihood of, whether you're going to prevail or not. And obviously in any litigation, it's never a zero-sum game among the attorneys. Each party thinks they can win the case, and so if you ask their chances, and I said, I think I got a 70% chance of winning, and the other side says, I got a 70% chance of winning, well, that adds up to 140, and that doesn't make sense. Everyone always acknowledges they may lose, but, and so I think he just wants the parties to have a discussion with him, so we can factor that into the mediation. And in my experience with almost all mediations in the last 25 years that I've done, there's frequently the mediation starts with everybody in the same room, and they talk just a little bit about their positioning. And then they kind of go back to the Henry Kissinger stage of shuttle diplomacy, where somebody goes back and forth, the mediator between the rooms, and says, well, here's what I'm hearing, and here's what I'm thinking you got to deal with as a reality check. And then he'll go back and forth, or she will go back and forth between the parties and see if they can start, coming together on stuff. I mean, that is typically how this takes place. And one of the realities I want to talk about tomorrow is, how do I learn about what's taking place in different portions of the mediation when I can't offer a solution? Okay, I mean, normally there's a party in there who can say, here's what I can contribute. And the only thing that has been mentioned in terms of sort of a public contribution is, is it conceivable that the city of Lakewood, if the parties can get together on a plan, if the city of Lakewood can promise to do its best to expedite the processing of that. And I can't commit to you on that either, but I said that's pretty much the only thing. And so one of the things I want to talk about is, how do I know what's taking place in the other rooms when I can't offer a solution? So that's, again, a long answer to your question of what are the legal realities and how does this work? I can't be an interested observer if I can only see half the game.
Yeah. That's I don't know if they'll have a solution for you or not. Good luck. I hope they have a solution for you. My second question is, what if I'm with what are we? Board member Miller, that I was really hoping that mediation would be where the parties ended up. And so whether it's courted or not, I'm happy they're talking to each other. I'm hoping they can come to a win-win situation, so to speak. But I'm wondering, what if it doesn't work? God forbid. What if it doesn't? What happens?
If it doesn't work, we're back they will, first of all, they'll notify the court, okay, that they've been through mediation and they don't have a solution. And so, they'll just kind of remind the judge that now it's time to think about taking action. And at that point in time, how the board wants to proceed is up to you. But you're certainly welcome to kind of, wait and see where things are headed. I mean, at the moment, I don't see an outcome in which the board could just escape being a party to this lawsuit, because there are other parties who are going to want to make sure that that whatever happens, you know, everybody who is a necessary party is there. And I'm having trouble understanding why an outcome in which the Board of Adjustment isn't required to be a named defendant, even if you take no position.
Mhm.
So I think that you could, you know, you could wait till see what happens, and then, you know, obviously I'll report back, and you can talk about what to do next, if anything.
So I'm hearing from you that at that point, we might have options, you know, that we could discuss. You know.
I think you always have options in litigation,
Okay.
but again, I don't think you guys can necessarily offer a solution to a development proposal. Right? You guys sat as an appellate body in a quasi-judicial capacity regarding a couple of interpretations, but ultimately the approval or denial of a development application isn't really, you know, the bailiwick of the Board of Adjustment, except for certain variances and stuff. But I think the opportunity will present itself if the parties can't come to a solution for a satisfactory, mutually acceptable development proposal, for the board to revisit where you want to go. And in the interim, I don't think anything is going to, I mean, I honestly do not believe anything will happen in this lawsuit until after the mediation. Because that's just, like I said, the courts have made clear, and I know how judges behave.
And so I want to add, I have also been inclined to just sit on this and wait, let see how things develop. Is there any constraints on this board in terms of our rules and regulations and our governing documents that would prevent us from being able to pick it up again once we give these guys a chance to take a peaceful way, which
I will go back to my current thinking, which we talked about last time, and that is that while an appeal of the administrative decision is pending at a district court, you don't have the authority to take any action on it.
right.
What you want to do in the lawsuit, you probably could, you know, there are different directions or guidance you might give me. My personal take is it's premature to do that. You will have the opportunity down the road, and I don't think any decisive action is going to come out of the court when he knows that they've scheduled a mediation. So it's unlikely things will change.
Yeah, and I guess I'm wondering, I don't know who could answer this question. Is there anything in our internal procedures that would prevent us from picking it up again at that time and discussing it and deciding on whatever? Are there any constraints?
I'm the person to address that, but I don't, you know, you're always entitled to discuss stuff. You know, decisive actions have to be taken by resolution.
Sure.
We don't have any resolutions pending
Right.
at the moment. I think there are some procedural things that you could contemplate. I'd rather not discuss them if we're not having an attorney-client executive session. But again, the only thing I'll tell you at this point in time is I believe that under Robert's Rules of Orders, a motion for reconsideration is now time barred. But there are other ways that you could pick up your discussion.
Thank you very much. That was extremely helpful.
Okay, thank you, Teresa. Let me see, Kathy Kittner has a hand up, and Johan, I see your hand up as well. Did you have an additional question? Might need to
Get my
unmute.
hand down.
Okay, very good. So we'll move to Board Member Kittner.
I have a few questions, and I guess it's okay for us to, we're kind of talking a lot about, I know you had originally asked for us to wait to talk about mediation, but it seems like it's okay to go ahead with that.
I think we've launched into it through Bill's introduction to a couple of points that he wanted to make up front. My feeling at this point is we should continue. And if we go into executive session, then at that point in time, I think our next topic, which I was going to bring up in general business, is how do we proceed?
Okay.
So I'd say continue.
Well, I would like to echo the comments that have been made so far. I know it started with Board Member Miller that, having the developer and the neighbors sit down and talking over what they want to see and coming up to some kind of a compromise or some kind of a plan that they would like, I think is a wonderful thing. I'm very concerned about what our lawyer, mentioned about the decision coming to us at some point of time is either the Board of Adjustment or the Planning Commission. And even if the parties do reach an agreement, there's a likelihood, or at least a possibility that would still involve coming to us as a rezoning. So I'm concerned about our having any kind of role in this mediation when the outcome, our lawyer can't take any position, and we really, I don't think, should be party to it if what they're coming up with is going to be, and that's what Mr. Tudhill seems to have indicated, that there's a likelihood that whatever comes out of mediation could come before us in a quasi-judicial capacity. So I don't know if there's a question in there or just an agreement with Mr. Tudhill and some food for thought there. And maybe, as you refer to the main parties, be involved in the mediation, but perhaps if that is not a role in the lawsuit that's appropriate for us, because we do have that potential down the road. You talked a bit about the cost and appeal and delay, and that we can't escape being a party at some point in time. But last time we kind of ended with discussing a way that we could kind of settle the lawsuit with the claims 1 and 3 and pull the Board of Adjustment kind of out of the lawsuit for now. And I don't know if that's the type of thing that I should bring up now, or if you would prefer to discuss that, Mr. Tudhill, in executive session. I'm happy to kind of pick up where we left off there.
I'd probably rather discuss that in executive session. There are some possibilities. But there are other parties to this litigation, and I'd rather have the conversation about strategy take place between me and the members of the Board of Adjustment, as opposed to the other parties at this juncture. To go back to your earlier comment as to whether or not it's appropriate to participate in the mediation, I feel that it's a worthwhile opportunity for me to understand what's going on, and that will help me predict the likelihood that the litigation proceeds, or that, how contentious the parties are, and be in a better position to advise you. But I absolutely agree. I mean, the merits of whatever might come up, and they have kicked around a couple of ideas in the pre-mediation, and I'm not going to share them with you because I agree there may come a point at which you'll be asked to either grant a variance or make an approval or approve or deny another interpretation of Director Parker's. And I don't want you prejudging those, but I do want to be in a position to be able to provide an informed insight into where things are going in the future.
So that makes me very uncomfortable, because I think that would almost imply a prejudgment, and there is a cost involved. And with all due respect, if we don't have to put out the cost for that, Because as you mentioned, we shouldn't really, as Board of Adjustment and planning commissioners, maybe not know those details. Then it seems that we wouldn't need to pay for an attorney to be there. And that we should go in open-minded with any land use. So I guess I just would appreciate if we all kind of think about that.
Okay.
Yeah, I actually have, are you complete?
I think
well,
probably most of my other questions that I have, Mr. Tudhill would prefer I ask an executive session, so I'll lower my hand and I'll kind of read through them and see.
Okay, well, I have my hand up and I have a question with regard to this situation. And this is, Bill, please, I'm sure you'll advise if this is better taken up in executive session, but my question has to do with our ability to act. And I'm looking for a parallel at City Council with regard to the ballot question 200, which became 14.27 in the code. Once the City Council lifted their self-imposed impediment on moving forward, taking action with regard to an issue, then they elected to move forward on 200 and adopt and implement 200 even while litigation was pending in appellate court. Is that something we can discuss here, or is that something we should discuss in executive session?
We could discuss it in executive session, but I am ill prepared to advise you on that. I have taken no role in that particular ballot initiative. Most of what I know, I have read in the paper, and I have heard a little bit from the parties that when City Council held a meeting and allocated residential development permits, Crescent Properties got cut out. And I know there's a lawsuit. I have not read the complaint. Consistent with Ms. Kentner's comment, and I will tell you, I have a good working relationship with Tim Cox, the city attorney, but I'm also budget conscious. And so I haven't involved myself in things that I wasn't retained to work on. So I can't really tell you how that issue might be resolved. But what I can tell you is counsel for the city, at least on behalf of Director Parker, and I know that the legal counsel they've retained for him, Pat Wilson, is working with Mr. Cox. They'll be in a position to figure out whether there's anything that they can do to get that resolved. But it's a collateral issue for me. It's an issue between the main parties in the case, but it's not one for the Board of Adjustment, and it's not one we could go into executive session and I couldn't tell you any more than I just told you.
Okay, thank you for the answer. Are there any other? I see Dale, you have a hand up.
Thank you. Kathy, I don't know if you were suggesting that we not have our attorney go to those meetings. Was that in the interest of saving money? I think that since we're in a lawsuit, if that's what you meant, I think we should have him go.
I had more to say about it to make it make more sense, but that was sort of what Mr. Tudhill said we should discuss in executive session. So I think I should probably explain it during executive session.
Okay. All right. Then I'll wait. But I will just say I'm glad that, and I think that we should have legal representation though, since we're named in the lawsuit. We'll see what else we have to say about it. Thank you.
Okay, thank you. Dale, are you complete? I don't see any additional hands at this point. So seeing no hands, no requests, I will close item 3 discussion and ask the clerk to read item 4.
I would, if I might, at least close it temporarily. If we go into executive session and you want to come back out and provide a little more discussion and direction, it's worth revisiting it.
Okay, well, I see certainly coming out of executive session that we might have a motion to take action, but I'm certainly understanding where you're coming from. If we need to continue the discussion, I think that would serve us the best. So either option I would consider open. Okay, so with that, now I'm closing item 3, discussion, and ask the clerk to please read item 4.
Item 4, request for executive session for the purpose of conferring with an attorney to receive legal advice.
Thank you, Mr. Schultz. Do we have a request for executive session? I see a hand, Teresa.
Make a motion that we go into executive session to consult with our attorney.
There needs to be a reference to the statutory provision
Sorry.
allow that, and those provisions are Colorado Revised Statute 24-6-402, paren 4B.
Do I need to redo the motion, or?
If you simply make the motion and ask that it be pursuant to the provisions that your attorney has directed you to, that's sufficient.
I make a motion that we enter executive session pursuant to the provisions that our attorney just read off for us.
So with the motion complete, do we have a second? I will second. So I believe, Johan, you have a hand up.
Well, most of my questions have been answered, and I'm pleased with the progress. I'm very much heartened by some of the things I've heard. I kind of wonder why we need an executive session at this point. Can someone maybe speak in support of the motion?
I can speak in support of the motion because I had questions that Mr. Tudhill indicated were not appropriate or were more appropriate perhaps in executive session. We ended our executive session last time with talking about a potential option for settling this lawsuit and perhaps getting us our names off of the lawsuit, at least temporarily. And I don't know if I should go any further than that. Because that's, I think, what Mr. Tudhill would like to discuss in executive session.
And I would add too that I have questions too further questions about our options. So I think executive session, I support executive session. I think it'll help us get further clarity. Are there any other questions or comments before we go to executive session?
I'll make one. I would tend to agree with Johan that I thought we covered it pretty well. That if we're in mediation, I'm not sure what action we would even consider taking, but I wouldn't want to prevent us or even vote against having a discussion. I think it's things are proceeding nicely and will be once the if the mediation comes to an end, then we will no longer be named in this lawsuit anyway. It will be resolved. And I don't think there's any reason to interrupt their process and waste their time and their money. We were talking about our own money and with the attorney, but mediators and all the parties involved are spending time and money on this. And I think it's not appropriate for us to even think about interfering with their process. We're not the ones who brought this lawsuit. That's what I think.
So, Bill, we have a motion to go to executive session and a second. This is not an item we normally vote on in my past experience.
It requires an affirmative vote of 2/3 of the quorum present in order to go into executive session. If this
Okay, great. So are there any further comments? Further discussion? If not, I will call for a vote. And please, let's do this by raising your hand. I will first ask for all in favor of convening an executive session to get legal advice from our attorney on our options to raise your hand. point, I will then call for all of those opposed to going into executive session to raise your hand. I don't see any hands. I'm sorry. I was
Mr.
looking
Miller
for
and
the-
Mr. Cohen have raised their hands.
I was looking for electronic hands, please. Let me clarify that. That's so much easier for me to keep track. Can we do this again? I'll make the original motion. All of those in favor of going into executive session for the purpose of receiving legal advice on our options to electronically raise your hand.
Oops, wait a minute.
Okay.
Do you want your hand up?
Sorry.
Pardon me?
Okay.
I didn't hear you, Dale. What did you say?
Oh, I think Johan got it.
Oh, that's
Okay.
right. I need to take my hand down on this one.
Okay, now, so that's the vote for in favor of executive session. Let's everybody lower your hands.
Wait,
I still see a hand raised, Rhonda. Okay, very good. The board is clear. So now I ask for a raising of electronic hands for all of those opposed to convening executive session. So the tally is 4 in favor of executive session, 3 against. Do I need, Mr. Rice, do I need to read the names of the votes? Or is that sufficient for the record? I see no answer, so
No,
I will not read the names.
I
Pardon me?
would be reading, and that's fine. If you want to read it for the public, that's fine. Trent and I have made note of it, and so we can make that for the minutes.
I couldn't hear you. It was really garbled. Can you say that again?
He said that he made a note of the votes and
Okay,
that yeah, he's got the names, or you could have them for the record if you'd like, but Paul did take notes of who voted for each.
Okay, I didn't take the names down. So if Paul's complete, feels like the record has what it needs, then we'll proceed. So Mr. Kirsch, can you guide us?
I think that
I heard a vote of 4-3 to go.
I heard 4 in favor and 3
correct.
against.
So we do not have the 2/3 necessary to go into
Oh,
executive
that's 2/3.
session.
It needs an affirmative vote of 2/3 of the quorum.
Right. So could
Thank
we,
you.
Insufficient.
Thank you. So we do not have the votes to convene. I was thinking a majority, not 2/3. So
as
thank you.
Mr. Tuthill said, I think we left item 3 open. Is it best to go back to there and have me ask my questions now?
I would
Sorry
like,
that I'm not able to ask them in private.
you can certainly ask them in private, and
I can't.
give me a phone call. We can have a one-to-one conversation. I'm always available to do that with some of the board members if you wish. We can't do it as a group because then it's a meeting.
Right, and I'm and my questions involve the whole group and potentially a motion to take action.
I have a couple of there are opportunities to discuss in the future. It doesn't sound like your board wants to go there. I do want this direction, okay? I want to know if I can participate, if I remain directed to represent the board and participate in the mediation and pre-mediation activities. And if there is going to be a representative of the board present, it would be helpful to me if you guys could collectively determine who's the most appropriate person, if anyone, to do that, or else you can say, well, Mr. Tuthill's a neutral. He's not the decision maker, will never be the decision maker. He won't be prejudging anything. He will just come and report back to us what he's learned and what's happening next. But I would like some direction in that score because I know in the past, some of you have expressed concerns that I hadn't heard from you about what direction to head in. And I don't want to head in a direction you don't want me to go. So if we're not going to have an executive session, if we could at least revisit item 3 to the extent that you could help me answer those 2 questions.
Very good. I think as Mr. Tuthill requested, prior to the discussion of an executive session, our next order of business is to continue with item 3. So with that, I will open it to a motion. Are we ready for a motion, or we want to discuss before a motion? I guess we're at the point of continuing discussion.
I don't know that you need a motion for either of those. I think some general guidance and direction is probably sufficient, because I don't know that it's formal board action. I wouldn't think of it as formal board action. It's just kind of a nudge.
I have a thought about that. I have expressed it already, and that's that I think we should let Mr. Tuthill go as our representative, the neutral representative. I take Kathy's point that we want to remain impartial and not be there. I think that any one of us that would be there could imply something, even if we didn't mean that. It could imply something to any participant in the mediation that we might do one thing or another. I think we just should stay away from that. And I think we should all, except for Mr. Tuthill, not attend the meetings and meet. I don't even care if we meet regularly to get your updates shortly after the meetings.
Well, hopefully you all got at least the last email I sent with a variety of pleadings and an update as to where things stood.
Yes, thank you.
You were clear in our last discussion that you would like to hear about developments as they, and by developments, I don't mean a development project, but as they came along, so.
Okay, Dale, are you complete? I think you're drinking water. It looks like you're complete. So I would see 2 hands up. Kathy and Teresa, I'm not sure who was next. I'll call on Kathy, and then we'll go to Teresa.
You know, I think that I understand as long as we are a named party. I guess I'd like to have the other discussion and as to where we feel, and I would like to know where my fellow board members would like to go with this, because at the end of our executive session, we had discussed that we could settle this lawsuit, that the board is being asked to, by the plaintiff, to simply vote again, not even have a full hearing and have to have a full hearing, but for the board to vote with an odd number with a complete board, because we had or the Board of Adjustment, I should say I was not on the board. At that time, the Board of Adjustment had a member who had resigned, and it was an even number and a tied vote. And our rules don't really tell us exactly what to do with a tied vote, although it does tell us what we need to take action. So there's some very good arguments for doing that. So I just want to clarify that one option we have would be to ask to settle claims 1 and ask the Board of Adjustment to be removed from the lawsuit as part of that by, I believe Mr. Tuthill called it confessing judgment. I don't know if that's the only option we have, or if another option would be to, well, if there is another legal term that would do that. I thought I wrote something down. And so I just want to clarify that that is what we heard at the end of our last executive session. And if the plaintiff agreed, we could settle the lawsuit if the plaintiff agreed to drop the Board of Adjustment, if we agreed to vote with a full board.
So I see, are you complete,
I think that was
Kathy?
a question to you, Mr. Tuthill. That was one of our options.
Yeah, are you looking for a response from Mr. Tuthill?
Yeah, I'm just to make sure I understand that correctly.
I think Bill may have there he is.
Qualms about having that conversation in a public meeting, and yet my client has just voted not to go into executive session.
I know, and I'm sorry, I
have thoughts on that matter, and I am, here's what I think I can say publicly.
Can I interject something? I'm sorry, Chairman, may I please? Because
Dale, let's let Mr. Tuthill finish. He has the floor, please.
I feel that we are talking about things that were in executive session that are not part of a public meeting. And I think we're getting into that ground, and that's not appropriate. I think this is a point of order. It's not.
I agree with Mr.
Thank you.
Miller on this. What takes place in executive sessions needs to stay in executive sessions. And I am not comfortable unless I was directed by the board as a majority to disclose legal advice in a public meeting. And so I'm sitting here, you can see the.
Okay, I think I have another, thank you. Now I understand. And I think I have another way to ask it that wouldn't say, because basically the way I said it was, tell us that that's what you said in executive session. Okay, so I think I have another way. And I was kind of hoping to wait on this, but I can always withdraw my motion later, but perhaps I could make a motion and have a second, and then we have a discussion on a motion, and then you could answer questions about it. So I believe at this point, I would like to make a motion that the Board of Adjustment direct our attorney to settle the current lawsuit against us by confessing judgment on claim 1, asking the plaintiff to dismiss us as a party, potentially ask the plaintiff to dismiss Travis Parker as a party, and to agree for the plaintiff doing that, we would agree to vote with a full board. So that would be my motion.
Is there a second? I will second. So we have a motion and a second. So we will open that to discussion. I see 3 hands up. Actually, Kathy, your hand is still up.
Yeah, I can take mine. Sorry.
Excuse me, who seconded it?
I seconded it, Johan. Dale, I believe your hand is still up.
It is, but I think Teresa actually had her hand up before me. Please.
Okay, very well. We'll start with Teresa then. Thank you.
So I actually had a question about our discussion before the motion, and I don't know if I can pose it at this point. Everything's kind of related. I was interested, well, you can probably hear it in my voice. I'm a little, I don't know, astonished that we, as a board, were not able to agree to go into a forum in which we could talk freely with our attorney and help our newest members get up to speed because they're plaintiffs now. I'm having trouble understanding that. But beyond that disappointment, I'm just wondering, Mr. Tuthill, in your attendance of the mediation, am I able to go back to that topic? What were you hoping to gain on our behalf, on behalf of your client, 1? And 2, with the answer to your dilemma of going back and forth and figuring out what's going on with both parties, would the answer to that be to have one of us or some representative along with you? Thank you.
Okay, 2 different questions posed there. The first one is what I'm hoping to accomplish. I am always of the opinion that more information is better than less. Not to the point it bogs you down, but I kind of want to learn more about where the attorneys for the main parties see this headed, so that I can provide better information to the board about the likelihood that you continue to participate in litigation, what that may look like, how long this process may go on. And if I am able to, I've participated in hundreds of mediations and settlement discussions in my career. And it's a way to help gauge where things are going. That's the answer to your first question, I hope.
And let me respond to that. As a communication person, I appreciate that. That being there on the ground, feeling things and hearing all the subtext and all that. And I think that's money well spent. So thank you for letting me interject that. Go ahead.
And second, how do I hope to gain that when I can't contribute anything on the part of the board? I mean, in most settlement discussions, you're contributing, money or an outcome or a change of job position or something to the prospective outcome. I would hope that in the conversation that we have with the mediator tomorrow, I can get him to act as a conduit to let me know how things are going. And what I can observe myself, I'll observe myself. And neither of the, or none of the lawyers for any of the other parties in this matter has been afraid to give me a call and express their opinions.
Okay, that's great.
As to the veracity of my advice and my client's behavior. So it's not like I don't know them all well. I know some of them better than others, but none of them has been afraid to talk to me. So I would hope that I would have the opportunity to converse with them and say, how's it going? What's the likelihood that I can go back in another few weeks and tell my client, you know what? We don't have to worry about this lawsuit anymore. Yeah. What's the likelihood that you're going to say, yeah, we're going to drag them through it for the next 3 years? And that's what I hope to gain and how I hope to gain it.
Yeah, that sounds worthwhile to me. And I appreciate that you're willing to do that for us. As far as the motion on the floor, I know you're going to open it up to discussion. Is it too early? Should I just go ahead? I'm not prepared to even vote on this without having an executive discussion where we can discuss it with Mr. Tuthill. I don't understand why that was blocked tonight. I'm sorry, I'm having difficulty with that.
I believe, just a point of order, and correct me if I'm wrong here, but I believe our motion does require a vote. And if
and discussion
wants to, following discussion. And if Kathy wants to clarify the motion, if that helps. But it's my understanding that that's the next step after discussion once a motion has been made and seconded.
I think
but we will have no opportunity to discuss the legal ramifications of this motion because we cannot go into executive session tonight. So I'm not prepared without that.
Well, at the risk of interfering with your discussion, it's not too late for someone to make a motion to reconsider the executive session.
Well, I've had my hand up.
I see several hands up. Yes, Dale, go ahead. Yes.
Thank you. So I first wanted to talk about the motion that's on the table. And I think in the comment, I would address the executive session question as well. I think that we're premature today to have this vote. I think we don't even, what will likely happen according to what Mr. Tuthill reported to us before, is whatever happens, there's going to be another lawsuit. So we're not going to be saving the citizens of Lakewood or the potential developer any money. We're going to actually wind up costing them more because we're going to change the rules partway through. I think, I would encourage us to consider withdrawing this motion because we're just not at a point we don't even know what they're going to discuss tomorrow. It could be that they have had some pre-discussions and they may be on the verge of a decision that we would interrupt. I just feel that very strongly this is just premature. And that was the reason I was opposed to the executive session, was because I think that even tonight's meeting is premature. To have it before the pre-mediation meeting and even before the first mediation on the 14th of August, I think I think we need to just wait to see what they're going to do. I am not upset with anyone on the board or anything like in that way. I just feel like we're getting anxious and we're trying to take actions too soon. Any sort of action. I think this is the point where we just see what happens. I mean, they haven't even had their first discussion yet, and we're trying to change the rules on them. I think that's just that's not the way a professional group acts. I think that's why I was opposed to continuing an executive session and that sort of thing. So I think we're a group that we'll act when the time's appropriate. That's what I think. And however we act, every time that we act as a group, whether it's Planning Commission or Board of Adjustments, when I was the chair, I always said the same thing, and that was when someone would say, well, I voted this way for whatever. I said, you don't have to explain your vote. We all vote the way that we vote. That's the way that it is. But there's a time, and I think that this is too soon. Thank you.
Thank you, Dale. I see Johan, you have a hand up.
Well, yeah, I concur with Commissioner Miller's remarks, and trying to think of anything that I could add to it in terms of this being premature, which I think it is. I'm somewhat, I have to say, I'm somewhat surprised and very much heartened that that these litigants have entered into mediation at all and seem to be rather hopeful about it. And I'm hopeful too. I think if they can get to some kind of concurrence on this, I frankly, having gone through all the pleadings, I'd like to see it go away, probably as much as the court does. It isn't that we couldn't take some action like this. Indeed, one of the scenarios, if the plea for summary judgment on the first claim for relief goes through, we could get it back, and then we would debate and go right to some of the issues that we went back to in February. I don't consider this very likely, incidentally, but it's part of what could happen. So I'd say let's wait just a bit longer. It may not have to be that much longer, but we ought to let the mediation run its course. And because I'm heartened by what I've seen so far. And like in any dispute resolution, I'd like to see it succeed. Thank you, Mr. Chairman.
Okay, thank you, Commissioner Cohn. I have my hand up, so I'm going to make a comment here. One of my biggest concerns is with regard to the duties and responsibilities of the Board of Adjustments as laid out in the municipal code and our rules and regulations as it relates to the fact that this case is being appealed. I think we all came together in the original lawsuit when the question was before us as to whether or not we had capacity to hear that case at that time. And I think we voted as a body together with no discussion. We all recognize that we have responsibilities and duties under the charter and under our rules and regulations. And these duties and responsibilities are also laid out on the Lakewood website in terms of the job application for Planning Commissioner / Board of Adjustment member. And where it says specifically, it says the board hears and decides appeals, and all decisions are made by a majority vote of the members at the meeting. That's in the code. It's duplicated on the website. And the result of our first meeting is we did not have a majority vote. So I think the challenge before us really is to be sure that by doing nothing, taking time, sitting back, not taking action at this time, we need to be sure that we are not in some way imperiling our ability to act under Lakewood rules and laws as a home rule city. If we don't take action to do our job, which requires a decision by majority vote of those present, I think we're abdicating our responsibility to the city. So I would propose that waiting is not in the best interest of the board. I certainly appreciate the thoughts and the reasoning behind waiting with regard to giving other parties an opportunity. But I'm very concerned about what that does with regard to our future authority. If we don't take action now to resolve claim number 1, then I feel like our ability to act in the future can always be called into question. And I don't want to see that happen. So that's kind of where I'm coming from. I mean, I see this not so much about the actual lawsuit or not the actual White Fence Farm case, but what I see this about is the lawsuit is a challenge to our authority as a decision-making body in a home rule city. And I'd like to see us stand together and acknowledge that we have a duty and an obligation to decide this by majority vote. So that's where I stand on it. I see Dale has a hand up again.
I do, but Mr. Tuthill wanted to speak, so I'm going to let him go first.
Oh, okay. I didn't see a hand. Bill, go ahead.
I don't even know how to raise the electronic hand. I've been scrolling around to figure out how to do it, but I can't figure it out. So I just went like this.
Okay. Dale can tell you because he instructed me.
I would like to, and I will reiterate what I have told the board in the past. I will act as your advocate, and I will take whatever direction you give me as long as it is not unethical or illegal. And no one has suggested that I do anything unethical or illegal. I would like to point out one practical reality, however, and that is one of the decisions that the board made that is part of the litigation challenge was made by a majority of the board. And that was the 4-2 decision with regard to Architectural Review Committee. And I just want to point that out that, claim number 1 is basically you guys didn't make a decision that's subject to appeal with regard to height and density requirements. But claim number 2 also relates to the Architectural Review Committee issue, and that's still gonna be there. So I don't, I'm just saying as a practical reality, I don't know that you get out of the litigation for the moment, even if you, as Ms. Kentner describes it, confess judgment, because you've got another claim that you did make a majority decision on. So just
we aren't going to get out of it. And thank you for that. And I think the law. I will respectfully, strongly disagree that we would be abdicating our responsibility. Absolutely, strongly agree, because the participants in the case have the right to appeal to a court, whether we voted 3-3 or 7-0. If there were all 7 people present and they didn't like the outcome, they could appeal it. That hasn't the fact that we were short one member has nothing to do with the fact that there is an appeal. And as Mr. Tuthill just pointed out, they're appealing one of the decisions that we clearly spoke as a majority about. So because they have the right to appeal, we're not going to be out of this no matter what. And what's more, we met our responsibility. I absolutely, and as I said, respectfully, very strongly disagree that we were abdicating any responsibility. Absolutely not. The rules are clear that if we have a quorum, doesn't require an odd numbered quorum, only that there's a quorum, that we proceed. And so as I said, in particular, because they can take this to district court regardless of what our vote is, either side. I think we are just being premature by doing this tonight. And as Mr. Tuthill points out, even if we change a vote for one of these, that we are still named for the other where we didn't have a tie vote. So we're not going to be out of this either way. I will say again that I think we should let this play out. This has been quite a process already that started almost a year ago, and I am happy to see that they are talking, because that's who should be talking, not us. We did our part as best we could. We met all of our responsibilities. We were named in a lawsuit, and as I said, if we had voted 7-0 one way or the other, one or the other party could bring this to district court too. Is that true, Mr. Tuthill?
Yes.
Absolutely. It makes no difference what our vote is. I would just ask us to not act like we didn't know what we were doing the first time, because that's what we're sort of implying. And I don't think that was the case. I think we were clear about what we were doing. There were some differences of opinion, and that is how it goes. But we as a group did our duty, our responsibility, and then everyone else has an opportunity to act, and that's what they're doing. I don't think it would do anything now except be a show. And I think one of the things that it could do, if we could change one of our votes, it could negatively affect the negotiations that are going on. So I once again would strongly encourage us to withdraw the motion to make this change now. There is plenty of time to do this. We're not going to run out of time if it goes that way. And we're not getting out of the lawsuit by changing one of these. Thank you.
Okay, are you complete, Dale? I believe you're complete. If not, let me know. I think I had my hand up first, and then we have Commissioner Cohn and Commissioner Bartlett, or Board Member Cohn and Bartlett. I certainly want to comment that you're absolutely right. I think that if we settle this lawsuit, that's not going to be the end of it. And I did not mean in any way, shape, or form to imply that it would be. There are other parties here, and there could be other actions here. My concern is about us doing our duty, and I'm not intending to imply any improper behavior. I'm simply looking at this in terms of the numbers. Our rules and regulations stipulate that a majority vote is required, and we did not achieve a majority vote. That is in no way a reflection on the efforts and the positions of the parties. I'm simply looking at the requirements in our code for how a vote achieves an outcome. So I just wanted to clarify that. And with that, I will call on. Go ahead.
You were kind of responding to what I said, and this has come up several times about the majority vote being required, and that is not what our rules and regulations say. It says that a majority vote is required to pass something, but it does not say.
No, it absolutely does say to conduct other business before the board. That's all inclusive.
But it doesn't mean, as Mr. Tuthill has told us numerous times, we're ignoring this piece of advice that he gives us, that according to other examples, a tie vote does mean something. something. It's not like it doesn't mean something. It doesn't mean that we didn't do our duty, which you just said. And I, again, strongly disagree, respectfully, that we did not do our duty. We did. And our rules don't say we have to have an odd number of people. They only say there has to be a majority to pass something. And when there's not a majority, it doesn't pass. Whether the majority is 2 to 4 in favor, or 3 to 3 in favor and opposed. And so I take exception to the repeating this as if it were actually a fact, that it makes it an invalid vote. It is not an invalid vote. And I think Mr. Tuthill has made that point numerous times. And if we want to change that in our rules and regulations for the future, we could do that. But the way that they stand and the way that these things have gone in the past, for this board and other in the planning commission and for the city council itself, tie vote means that it just doesn't go. It doesn't mean it's invalid and we wait until we have some odd number of people. Thank you.
Thank you, Commissioner Miller. So I believe, Alex, your hand's been up a while. Also, we have Johan and Rhonda. So let's start with Alex. Okay, I don't see Alex.
I was muted.
Oh, I'm sorry.
I feel like I've said that about 100 times since COVID started. Won't be the last time. I'll try to make this quick. I mean, I think Board Member Miller kind of just spoke to a lot of the points I wanted to make. I mean, our rules do specifically state that the Board of Adjustments needs a quorum of at least 5 members. Okay, we had 6. I strongly agree with Board Member Miller that we carried out our duty to do the best that we could to vote that night. I mean, it's unfortunate we had a split vote, 3-3, but I agree with Board Member Miller. I think that it did mean something. Unfortunately, in a case of a tie like that, the motion doesn't pass, but it means something to me. And I think, unfortunately, at this point, our ship has sailed. Currently, it's under appeal. I'd like to see the mediation work out. I think that trying to interject ourselves back into the process now gives a perception that maybe we want to see a different outcome, and I think that's a bad thing for the board. And I'm willing to wait and see what plays out in mediation. I don't see a risk at doing that or to not going into executive discussion tonight. We had 4 hours of executive discussion the last time we met on this topic. I would like to continue seeing Mr. Tuthill represent us and bring information back to us, but I think we should remain kind of where we are until we see how things are worked out. And to me, it's just very simple. That's how I feel about it. And I think we could debate all night about our rules and what it says. It was clear to me that we carried out our duties to hear the case. And unfortunately, this is where we are, but I think that we need to wait and see where the mediation ends up.
Okay, thank you, Alex. Next hand, I believe, is Johan.
Thanks, Mr. Chairman. I agree with both Mr. Miller and Mr. Bartlett, but I have two, I would disrespectfully, or I would respectfully disagree with some of the Commissioner Held's observations. I think if we were to insert ourselves in any way this early in the litigation, it wouldn't make us look very good at all. It'd be something of an embarrassment. I also, and I'm usually don't, if I'm on a public body, public bodies don't always look very good, even when they make a correct decision. But in this case, I think we really would look like a ship that had no steering apparatus. And I would say too, that looking at some of the rumblings out there in our correspondence, we could make life pretty complicated when it doesn't need to be. That if we were to do this kind of direction to our council at this particular time, we probably wouldn't gain our objective, and we would probably make, in my judgment, introduce additional complexity. Now, Mr. Tuthill, you might chime in on this a little bit if you want to. Because you know, and this is something of a crystal ball, really, but I see this just prolonging things rather than move them to a resolution. And that's about as much as I care to say right now. I think in the future, we might want to look more closely at this kind of action if this case is not resolved. But I'm hopeful at this point. So thank you.
Thank you, Johan. Rhonda.
Yeah, I wanted to comment that I had listened carefully during our last session and did some research, and I came back with questions that I was hoping to have answered during the executive session. I'm disappointed that I wasn't able to ask those questions, and it's I think put me in a difficult position for something like this. But one of the things that I certainly agree with a lot of the points that have made here. I do understand that making a decision at this point could, you know, impact the parties. It could introduce delays because it could end up coming back. At the same time, I am an engineer and I always look things up and I go back to the source. So what I can talk about now at this point is that, for example, when it was discussed that we needed a 2/3 vote to be able to go into executive session, first thing I did was go to the city code and I looked that up. And in section 2.01.010, indeed, it did say that we need a 2/3 vote. So when it was discussed last time that not having a majority vote, being, you know, having a tie vote meant that whatever it was doesn't pass. Well, the first thing I did was similarly go to the city code. And in section 2.16.030, the exact language that defines what the body, you know, should have done or how it's handled in that case, it says all decisions are made by majority vote of the members present at the meeting. And so I think there's a difference, because we heard from other commissioners tonight that you need a majority vote to pass something. But that's not, the city code says that all decisions, it doesn't say an affirmative decision, it says all decisions require a majority vote of the members present. And that's in, again, section 2.16.030. So I do feel that there's a conflict with the city code. I understand that it's maybe not in the best interest of the parties or this case to vote or to take, you know, to re-vote and to go through the process as the motion on the floor has suggested. And I'm certainly very sympathetic to that. But as an engineer, I look back at the wording and the language doesn't say to pass something. It says all decisions, and that was a decision. So I'm very concerned about that. So I kind of agree partially with I think some of the conflicting positions. I agree with part of this side that says we shouldn't, and I agree with part of this side that says we should. So I'm very conflicted on this, and I'm concerned that I wasn't able to go into executive session to be able to fully vet and discuss that. Thank you.
Okay, thank you, Rhonda. Kathy, I see your hand up.
Sorry, same thing as whatever Alex said earlier. No. So I guess first I have a question and then a couple of comments also. There seems to be a notion that somehow taking the Board of Adjustment out of the picture of the lawsuit would stop the mediation. But at the very beginning, Mr. Tudhill said that the mediation is really between the two main parties and the Board of Adjustment is just an observer. So does the Board of Adjustment getting out really technically have any impact on the two main parties mediating and coming up with something?
As a technical matter, no.
Thank you.
As a dynamic changer, yes.
Okay, well, and so then as far as I kind of want to talk about our responsibility as the board to hear and decide. And I think, thank you, Board Member Peters, for kind of finding that specific language also in the code. The other reason that I think it's important, that I think just a food for thought, is the message that we send to our community. And those, because I heard from at least one, if not two of you, that it really doesn't matter if it was tied or 4-3 or 7-0, because somebody can always sue. Well, I'm sorry, I'm a public school teacher and a single mom. No, that is not true. And our city code needs to be there and be able to be utilized and get a decision also for the people who do not have the means to go to court. So I would also like to consider that fulfilling this, as somebody else mentioned, has implications beyond just this case, and that we owe it to people who come to us for a hearing to give them a decision. So I guess I have that food for thought. I think that there's actually a chance that we could speed things up. I agree with the notion that, and I don't think anybody wants to see this piece of land go dilapidated and not cared for. So I think I could actually see that it could help speed the process up if we take part of this off of the table. And another question I have is, if we were to come to a decision, Mr. Tuthill, one way or the other, would that then take Mr. Parker, an employee, out of the likely out of the equation? Because it seems this was, I think, somebody else, and I can't remember, but it does seem a concern to that he is, as an employee, bearing a responsibility that he doesn't need to have, that if we as a board had made the decision, we would be bearing in the lawsuit.
Board Member Kender, I haven't really thought that particular question through at this juncture. And I'll confess that. I mean, I know that the city believes that Mr. Parker's interpretations were correct, and they originally retained me because they wanted to defend those interpretations, and they could not at the same time provide independent legal advice to the Board of Adjustment. And so, you know, normally this city attorney represents the Planning Commission and the Board of Adjustment, but they knew that it was inappropriate for them to do that. So I don't know if they would continue to defend the position of Director Parker. I am fairly confident that if, and without talking to them about it, I am fairly confident that the developer's attorneys, they're content with the decisions that have been made to date and the interpretations that have been made to date. I would not be surprised if you directed me to try to settle or confess judgment if the developer's attorneys didn't seek some injunctive relief that prevented you from having another vote. I don't know what the outcome of that would be, but I would not be surprised in the least if that was their next move on the chessboard.
But we wouldn't know unless we did something anyhow. All we know.
I am speculating. but
All
I'm-
we know now is that the main parties are in mediation. We're just an observer. And this could go on a long time. So I just wanted to say that we really don't know about timing because I think it was mentioned that our taking action could somehow delay things. And I think it could actually potentially have the opposite effect. We don't know. And the other question I have is, as part of confessing judgment or stipulating whatever, I wasn't really prepared to make an exact motion. Part of my motion was to remove the Board of Adjustment totally from this lawsuit. Could that be something we request of the plaintiff? Because it was brought up that we would still be part of another part of it, but could we request that to be part of the stipulation or confession of judgment? It's kind of like a.
You can pitch almost anything in a settlement discussion. So I'm not going to say it would be off the table. I'm just saying, to the extent that what's motivating some of you seems to be this frustration, maybe is not the right word, this level of uncertainty created by a 3-3 vote, that one of the issues that's before the court is not a 3-3 vote. And so
exactly. And I don't think we.
That said, it's again, it's my opinion is the developer's attorneys are not going to let you go quietly.
Okay, but
Even
this
if you
lawsuit
want
is
to,
not-
but that's based upon my experience and background, and but it's no guarantee. Okay, they may decide that, well, let's just see what happens to mediation, and I can't tell you for sure, but I'm pretty confident they like the result they got so far, and they're going to do a lot to try to defend that result.
Well, it would seem the sooner they come to us with a plan that they both like, the sooner all of this could be done and everybody could be happy. And I think that is one of my goals with what I have proposed tonight. And as I said, to remove us from it. But isn't it, you mentioned the developer and their position, but isn't it the plaintiff who brought the lawsuit? So if we confess judgment to the plaintiff, they could choose whether or not to go forward with all the rest of it or not.
I mentioned earlier the Rule 19 of the Colorado Rules of Civil Procedure that allow indispensable parties to be required to participate in litigation.
Yes, if there's a lawsuit, but if the plaintiff chose to not continue, it's the plaintiff's choice, not the defendant, right?
Either one could decide that you're an indispensable party for the relief that's being requested.
So I'm not asking my question right. My question is it's the plaintiff that could decide to just drop the lawsuit, and then the defendant, if they didn't like it, would have to start a new lawsuit.
The defendant would basically declare you an indispensable party that has to participate. I mean,
I'm sorry, if the plaintiff dropped all of the claims, not just claim one.
Including the claims against the developer?
Yes, because that's up to the plaintiff, right?
If the plaintiff drops the claims against the developer, they can drop the claims against you. But if the plaintiff continues against the developer, I'm fairly confident the developer is going to want the Board of Adjustment to continue to be a party in this lawsuit in some form or another.
I think that's all that I have for now. Thank you.
Okay, thank you, Kathy and Bill. I see two hands up, Dale and Johan. I am not sure who was next. Dale, would you like to lead, or Johan?
Sure, I'll go ahead.
All right.
Early Dale.
Okay, thank you. I will say that I am familiar with what the code says, and I think as with other places in the code, it's not clear. In one of the roles of city council and for us has been, I think for all sorts of government organizations, is to clarify their rules and their codes and that sort of thing. I will say respectfully again that I strongly disagree that a tie vote is not a decision. The if that were the case, then every time there's a tie vote, it would be taken back, and that's not what is the reality. So I did want to make that point. I also wanted to make the point that we. Board Member Kentner, you have said several times that we would the Board of Adjustments would be removed, and then you've also said propose to them that all of those. First of all, we wouldn't be removed by voting, as our attorney has said, because they are actually they included all of our decisions, even the ones where we voted 4-2, the one where we voted 4-2, and I want to reiterate again, in spite of all the things that have been said, that we are just premature. And I want to ask our legal advice. I think we have ignored legal advice several times, including an executive session. And so I'd like to ask here in public meeting, if we waited until after mediation begins in August 14th to hear from you and then make a decision about this motion or another motion, would that be too late?
No.
Okay.
Sometimes I'm capable of giving a short answer.
That's fine. I think that's clear enough. Short answers are nice, and I think I think even on all sides, where there's a feeling amongst some people that, or some of us, that we feel like we're just a little bit soon on this. But we're not going to be too late if we wait until after the mediation starts. I think there's no harm in waiting, and there is potentially benefit to everyone, including to us, as Board Member Bartlett pointed out, including to us and how this board appears. We are regularly told that we're in developers' pockets, or that we are just do whatever the city wants us to do, and those kinds of things, none of which have ever been true for me, and I don't know of any board members that it's ever been true for in any votes that I have seen. But when we do something like this where it's not called for yet, I think we risk people outside accusing us of that sort of thing, of stacking the deck, or of acting not according to the evidence that we're seeing. So I will again appeal to the to Board Member Kentner to withdraw her motion for tonight, because it won't be too late if we wait until next month. Thank you.
Thank you, Dale. Johan, I believe you're up. I think you're muted.
I know most of you aren't good at reading lips, but I'm not. You know, before some of you accept Mr. Tudhill's invitation to confer with him, I might suggest that you go back, and I know there's an awful lot to read in our materials, and I'm kind of defeated by the content myself, but you might want to look at the correspondence that was addressed to us, first by Brownstein, Hyatt, Farber, and Schreck on June 23rd. And then, you know, if you want to get the, especially get closer to Mrs. Kettner's argument, you might want to look at Ireland Stapleton's letter of June 24th and try to do some comparison, and then proceed from there, because from what those attorneys are telling us, this kind of direction isn't going to resolve much. It's simply going to prolong things, if it has any effect at all, at least in my present observation. But I think we need to let this, again, and this repeating myself, we need to play out further. We've got a lot of matters before the court right now. And if we let it play a bit longer before we take any additional position, which the court may give us anyway, we wouldn't be wasting anybody's time. would, and we'd make things a good deal less complicated. Thanks.
Thank you, Johan. Rhonda, I see a hand up.
Yeah, I have a lot of questions and a lot of thoughts. So I've heard here that there's no harm in waiting until the mediation, and I think that's a statement that I have questions about. I'd like to explore and understand more. I think that the motion that's on the floor, I don't know if it's a motion that would achieve all of the goals without some amendments. And what I'm hearing here are questions about if this motion was made and approved and we went forward, does it really relieve the board from being a party? Does it relieve Mr. Parker from being a party? These are some important questions. And I think that there's a lot more to this than just the motion that's on the floor can really cover, and we would need more discussion to make a decision. Again, I'm concerned that we didn't have the opportunity to go into executive session to be able to flush some of this out, but maybe some of it we need more time. I don't know. I know that there's also been a request for Commissioner or Ms. Kentner to withdraw it, but I believe under Robert's Rules of Order, once a motion has been put on the floor and seconded it is out of the hands of the person who made the motion. And so it is the property of the governing body at that point. So I believe under Robert's Rules of Order, she may not be able to withdraw it, but I'll, defer to maybe our legal counsel or others. But I did read that. So I'm trying to reconcile what, what the city code said, which seems pretty clear to me, which I do have concerns. I feel like I don't know who made the decision at that point that a tie vote was a final decision, because it clearly says in the city code that decisions are made by majority vote. There was not a majority vote. So I have questions about that, but obviously it has implications for the parties and the suits. And if a motion like this did go forward, I would want it to be as minimally impactful and to maybe have some amendments and some considerations. So I guess at this point, I'm just sharing my thoughts and my concerns. Maybe there are some responses and thoughts that others have, including our legal counsel. And I guess it's a very difficult position that I think we're in right now, because we don't have the benefit of an executive session, but just trying to work through this as best as I can with the information and the documentation that we have at hand. Thank you.
Point of order. Go ahead, Mr. Tuthill. I'll defer to Mr. Tuthill.
Go ahead, Bill.
Okay.
Thank you, Johan.
I was just waiting for my turn to be recognized. And now I lost my train of thought. This is.
Let me raise my point of order. A motion can be withdrawn by the maker and the consent of the second.
That's generally my understanding of it. I am not an expert on Robert's Rules of Order, but my experience has been with the consent of the second. They can be withdrawn. I know that board member Peters has, questioned whether it's there's any rush or whether you've got all the time in the world. I'm just going to make this fairly simple observation. I think my interpretation as advanced in the lawsuit as to what the effect of a 3-3 vote is correct. But if I'm wrong, a judge is going to tell me that, and then he's going to send it back to you anyway. So.
I'm going to raise my hand and call on myself with regard to that point. You know, I think it's clear from the language of the municipal code and rules and regulations that it does require a majority vote. And I think, you know, acknowledging that could cut some of the expense and time, as Board Member Kentner said. So I would like to, you know, leave that thought dangling out there. And I also feel that it's important with regard to a tie vote to look at the context of where that has meaning. I think, Bill, as you educated us or provided your input in the original hearings, that's how a tie vote is treated in state law and in federal cases. You mentioned the Supreme Court example. The distinction I would like to make here is that we are operating under home rules as a home rule city. We are not bound necessarily by state law or federal precedent. We are required under our rules to make decisions in accordance with what those rules stipulate we do. So I think it's important to recognize that in some cases, a tie vote has meaning. Under Lakewood law, a tie vote does not have meaning. And I think I just wanted to draw that clarification, which is the basis for my comments, that I think we have further deliberations to do and further work to do to get to a majority vote. That's all I have. I see Kathy has a hand up.
Thank you. I think my comments were going to be much like yours. You know, that there is the argument that court direction takes away our home rule sovereignty. Do we really want a court deciding this for us? And do we want to, early in Mr. Tudhill's comments, he mentioned the courts being busy. If we can settle this and take less of the court time, that would seem to be a responsible thing to do. As a point of order, I've gotten feedback a couple of times. I don't know if people are muting themselves when they're done or if anybody else has had that.
I've had some feedback, yeah.
And then I was wondering, instead of withdrawing the motion, I would definitely be comfortable. As I mentioned at the beginning, I wasn't really prepared to make the motion. I was also hoping that we would go into executive session and have some discussion that way first. However, I'm not comfortable just withdrawing it and not having any kind of further knowing what's going to happen next. Would it be possible, would this be part of Robert's Rules of Order if we table it to a date certain of August 5th?
Again, I'm not a strict parliamentarian, but I don't know why there's any reason you can't table it to a date certain.
Then I would like to suggest that, unless there's more discussion, that we table this to a date certain of August 5th.
Kathy, I'm going to jump in. I believe we have a potential public hearing on a rezoning. Is that August 5th? Somebody maybe can tell me, Paul?
That's the first Wednesday of the month.
Yeah.
It's August 5th, yes.
Yeah, so we have a conflict on that date.
Or we would just have to have discussion on two different items, yeah.
Well, the first would be a board of, would be a planning commission public hearing on the rezoning. Then the second would be a convening of Board of Adjustments. We can certainly do that.
So Commissioner, or excuse me, Board Member Hills, can you hear me this time?
Yes, Paul, there's some feedback, but I can hear you.
Okay. So Monday, so we haven't got to the board or the commission yet. We may be rescheduling that rezoning on August 5th. We think the applicant has a conflict.
Okay.
So I'll confer with Aaron. We were supposed to find out, I think, by Friday. I'll confer with Aaron tomorrow whether we know. And we can push it to that date if you want to use August 5th. And we just follow up after the planning commission meeting. So that's fine. But I think the calendar is going to be clear on August 5th.
Can I
Okay.
suggest a date of the 19th, which would be after the first meeting of mediation, which certainly wouldn't be resolution after one meeting, but we would have a good sense, I think, of what's happening. I like very much the idea of tabling it. I think we have to, according to Robert's rules, we have to table it until a specific date. And so if we can,
Well, my
To postpone it indefinitely, it generally is a death penalty for the motion. So, but nothing keeps you from making a motion at another meeting.
I would like to propose that we table it to a date certain of August 5th. We already all have that on our calendar, and it's looking like it might not be a long night. And we either 7 p.m., either after the at the conclusion of the planning commission meeting, or at 7 p.m. if there is no planning commission meeting.
So do we have a second?
I'll second that.
Okay. Thank you. Any discussion? I see 3 hands up.
I'm sorry, my mistake.
Okay, there's 2. Rhonda and Teresa, do you have discussion on this?
I have a couple of questions. What is the purpose of tabling the motion? What do we think we're going to gain by the extra time? And this discussion of home rule, does that need to be unpacked for some of us that, just if you could unpack that just a little bit for the rest of us, why that came up. So just those 2 things.
I think the reason I brought it up was because as a home rule municipality, it's our rules that apply, and we're not a statutory, maybe I should punt this one to Bill, because we're not a statutory municipality. We have our own governing rules and bodies and rules and regulations. We do not follow the state rules. We first follow our own rules, which must be at least as strict as the state rules. But we set our own.
In general, that's a fair synopsis. I don't know that it applies here because what we're doing is interpretive analysis of existing law. And I think there's a fair amount of existing law out there that says when bodies tie equally, there's a result. But I could certainly kick the question around in my head between now and the 5th of August. If I could shed some more light on that particular angle.
I see. Are we complete there?
I'm sorry. No. What was the other part of the question? I'm sorry.
The
It was a
other
two-part question.
part of the question.
What are we hoping to gain in the?
Yeah.
in the-
Well, I was hoping, and I should have made this as part of my motion, I'm hoping that by August 5th, maybe we can get an agreement to go into executive session and flush some of these things out a little more. That's my main goal, I guess. And if not, see where we are then.
And I appreciate that because I believe that the statements that were made by the board members who blocked the executive session tonight is valid or as they are, because you guys are new, it hasn't been explained to you why, the reasons behind their opinions. And I think if we go into executive session and get, you guys up to speed with the rest of us, I believe that was the plan, was that you would go read the materials and we would come back and talk about it. So I'm hoping on August 5th, we will all be prepared to have that discussion. So thank you.
Okay, I see 2 more hands. Rhonda and Johan, I'm not sure who was next. Who would like to go?
I'll defer to Rhonda.
I'll go ahead. I've
Thank you, Johan.
been up for a while. So I do support postponing this. I think I've been pretty clear that I have some, questions, and I'm not really prepared to make a decision on the proposal that's on the floor. I think some of the information that I appreciate that Mr. Tuthill said he'll be thinking about the home rule versus the statutory piece. I also, another question that was asked of him related to, would Mr. Parker be removed from the lawsuit if this, if we move forward with this? And then I guess also my, my concerns that maybe the motion that's on the floor could be revised. Maybe there's ways that the same end result for the for our board could be achieved with a minimal impact to the party. So maybe thinking about that and some possible amendments, or maybe revising it, putting a second motion out as a possibility. So I support tabling it to August 5th, as has been discussed.
Very well, thank you. Johan,
I see Mr. Tuthill wishes to address us, so I'll defer to him and follow up afterwards.
very good. Thank you, Johan. Bill, go ahead.
Sorry to jump in, but in response to Ms. Peters' comments a moment ago, I would be surprised if the lawyers for Brownstein Hyatt and Ireland, Stapleton, and Pryor aren't watching with keen attention this public meeting today.
Right.
I noted earlier, we have a follow-up meeting tomorrow in the pre-mediation, and one of the things to talk about is the legal realities. I am certain these topics will come up, and so to your point of, what happens to Director Parker if a motion such as Ms. Kentner's were to carry, how does that look? I imagine we're going to have a conversation tomorrow morning at which these topics come up. And therefore, if you do continue this discussion to August 5th, to respond to, I think, Ms. Stone's comment earlier, what do I hope to get out of the mediation? I think I'm going to get an earful tomorrow on this. And I will be happy to bring that back to you on the 5th of August, or if it's the sort of thing I could report in advance, I will do that. So if you do continue it, I am fairly confident that I will have additional information as to what impact this might have.
Alan, may I interject a point of order?
Yes, go ahead, Dale.
We actually, within our Robert's rules, could continue this meeting to August 5th. We wouldn't have to close this meeting. We don't have to have these votes. We can continue the meeting until August 5th.
We can do that too.
We could remove the motion to table. The motion would still be there. We could just continue to August 5th, and that may be the simplest way to do it. I want to make that suggestion.
I would agree, and I would withdraw my motion to table.
I was the second, and I will withdraw my seconding of that motion.
So at this point, do we need a motion to continue?
Yes, to continue, you have to have a date and a motion.
I will make a motion to continue this meeting to a date certain of August 5th at a time either following the Planning Commission meeting or at 7 p.m. if there's no Planning Commission meeting.
Very good. Do we have a second?
I'll second, yes.
We have a motion and a second. Any further discussion, Dale, while your hand's up?
Thank you, no, and I believe I brought up that point of order over Johan in case he had something he wanted to say.
Okay, yeah, my hand's up too, but let's first go to Johan.
Thank you. Just to respond to, I believe, Mrs. Stone's inquiry, I believe that we would benefit by reviewing our correspondence from Brownstein Hyatt and from Ireland Stapleton. I think those are letters of June 23rd and 24th. And I know it's tedious to reread something you've read before or perhaps skimmed over, but I believe I would urge you to look at those more closely because they summarize a lot of other things that are in front of us and that we've been talking about. So that was just what I wanted to add. Thank you.
Okay, very good. Thank you. with my hand being up, I wanted to respond to Teresa's question about getting more information, if I understood the question right, getting more information with regard to what home rule means. And I think this plays into Bill's comment that, we have been discussing in various forms the interplay of state law and local rule law. So I think I would like to suggest, first of all, I'll say I too support continuing this meeting to August 5th. And in the interim, to suggest a source for people that might want to look at it. University of Colorado Law School online has a Powers of Home Rule Cities in Colorado. And it's thorough. It begins at the beginning, and when the Constitution added Article 20 to create home rule. And I appreciate the question, Teresa, if I'm hearing you right, that more clarity on what home rule means would be beneficial to our discussion. So I just wanted to make that suggestion that that's a place where people might read. Bill, do you have any other?
If I can respond and clarify,
Oh,
really,
certainly.
I'm concerned with specifically the impact of, pertaining to this case, not necessarily to understand how it works, but this tie vote and if the district court comes back and says no, all that, does it weaken the home rule? That's specifically what I'm interested in, just to clarify.
I will do my best to at least think about whether it has any impact on my legal analysis. Again, I won't be surprised if I hear insight from other lawyers who have an interest in trying to inform my judgment. And I will also make note that I spent 13 years as the Broomfield City and County Attorney. They got their own constitutional amendment that gave them the broadest powers you can conceive of in the state of Colorado. And so for many years, I operated under a principle that it was astonishing what that particular government could do that other governments, even home rule governments, couldn't. So, but they got a constitutional amendment to do it. So I will at least try to have an open mind and think about whether it may impact the legal analysis. I don't know where I'm going to come out on that, but I have to acknowledge that I haven't really wrapped my brain around it yet, but I will do it between now and the 5th of August.
So very good. Seeing no more hands, then I call for a vote on the motion. Kathy, would you state the motion one more time?
Yes, I moved and Dale seconded that we continue this meeting to a date certain of August 5th at a time following the Planning Commission meeting or at 7 p.m. if there is no Planning Commission meeting.
Very good, thank you. So now let's do the vote by raise of hand. I will first ask all in favor of the motion to raise your hand.
Wait.
Oops.
I believe I see 7 hands. It is unanimous that we will continue the meeting in accordance with this motion.
Mr. Chairman, can I just make one additional comment here?
Oh, yes, sir. Go ahead.
Thank you. Several of you had some questions tonight that you were hoping to ask in executive session. There are 2 things I'd like to say. One is that at any of your regular or special meetings, you can go into executive session. If you know you're planning on doing it, you should notice it up in advance. So the agenda for your next meeting may include that prospect as well. In addition, to those of you who may have some individual questions, you and I can have a conversation. Feel free to give me a call. I'm not going to dole out my cell phone number here on the at the public meeting, or I'll get calls from people I don't want to hear from. But I think the rest of you know how to get a hold of me. It's a little late tonight, but if you want to call me sometime in the next few days, feel free. Thank you, Mr. Chairman.
You're welcome. So with that, I will close item 4 and ask the clerk to read item 5.
Item 5, general business.
Very good, thank you. I mentioned earlier on that it was my intention to bring up mediation in general business, but I think we've thoroughly covered that. But is there any more discussion people would like to have regarding mediation? I see Johan has a hand up. Johan.
Sorry, I gotta watch that a little more closely. That I did not intend to have my hand up. Mr. Chair, I've withdrawn my hand.
I think he's frozen, Johan.
Yeah,
Oh, no.
it's like something's, our chair seems to have a communication problem.
So what do we do now? Do I go on? Continue on?
What does Robert's rules say when you're
Hear us.
freezes? I haven't read that.
Usually
know
in the
either.
absence of the chairman, somebody else can elect if you guys don't have a vice chair.
Oh, we have a
I am
vice
the-
chair.
We
That's-
do have a, there
Okay.
he is. Hi, Alan.
Boy, I lost my feed. Did everybody lose theirs as well?
No.
No,
Okay, it was just me, I guess. Anyway, we're back. So I had asked Mr. Rice, do you have an update for us with regarding to a group commissioner email for the public?
Oh, yes. So, yes, we have made that request and we're working with IT. And as soon as we get that group email, we will get it up online and let everybody know.
Very good.
Okay.
Dale's got a thumbs up there. Thank you, Dale, for the suggestion. Do you have any further comments?
No, thank you.
Is there any other general business? Very well. Then seeing that we have no general business, that will conclude item 5. And at 9:12 p.m., we are adjourned. Thank you, everybody.
Thank you, everyone.
Guys, have a good one.
Thank you.
thank you. Have a good evening.
Goodbye, everybody.